We'll hear argument first this morning in Case 23-411, Murthy v. Missouri. Mr. Fletcher.
Thank you, Mr. Chief Justice, and may it please the Court. The government may not use coercive threats to suppress speech, but it is entitled to speak for itself by informing, persuading, or criticizing private speakers. Like Bantam Books, this case should be about that fundamental distinction between persuasion and coercion. But unlike Bantam and the case that you'll hear next, this is not a typical suit where a speaker challenges government actions affecting its own speech. Instead, 2 states and 5 individuals are trying to use the Article III courts to audit all of the executive branch's communications with and about social media platforms. That problem has infected every step of this case. Respondents don't have standing at all because they have not shown an imminent threat that the government will cause a platform to moderate their posts in particular. But the lower court still reviewed a vast range of speech by different officials to different platforms about different topics at different times without asking whether it had anything to do with respondents. And the courts then entered a universal injunction restricting speech about any content posted on any platform by anyone and binding thousands of officials, including presidential advisors speaking to the public and FBI agents trying to protect the nation from foreign threats. Even apart from the Article III problem, that injunction rests on 2 fundamental legal errors. First, the Fifth Circuit radically expanded the state action doctrine by holding that even concededly non-coercive communications, like the CDC's public health advice, can transform private platforms' editorial choices into state action. And second, the Fifth Circuit mistook persuasion for coercion. It held that the FBI's communications are inherently coercive because the FBI is a law enforcement agency, a theory that even respondents don't defend in this court. And it held that White House officials engaged in coercion because they used strong language or referred in a general way to legal reforms in response to press questions. If this court reaches the merits, it should reaffirm that government speech crosses the line into coercion only if, viewed objectively, it conveys a threat of adverse government action. And because no threats happened here, the court should reverse. I welcome the court's questions.
Mr. Fletcher, is the coercion encouragement framework out of Bantam book the only way to look at this case?
So I think there are 2 ways to look at this case. I think one of them is the coercion inquiry, which we think comes from Bantam Books. You can think of that as an aspect of state action because when private parties are compelled to act, as the court said in Halleck, they become state actors. We think that's the right way to think about this case. Respondents in the lower courts have also proposed a different way, the state action way. They've suggested that even absent coercion, the government speech, if it encourages, in some colloquial sense, private action, it can turn that private action into state action.
Do we, just so I understand your argument, do we normally apply state action doctrine in cases involving the government or private parties?
Both, I think. You know, in some state action cases, you're asking someone who's suing a private party and alleging that that private party is bound by the contours of the First Amendment or other constitutional provisions because they're state actors. You see some suits like that look like this, suits against the platforms, suits against Stanford University, which is referenced in its amicus brief here. But you also see suits against the government based on conduct by private parties. That was the case in Blum, and that's the theory that respondents are pursuing.
Are there any First Amendment cases?
Any First Amendment cases, I'm sorry, that
employing state action doctrine.
And suing the government. Off the top of my head, I can't think of one.
So they're usually things like Medicare or government contracts or relationships like that.
Yeah, and I think what that gets at is that it's very unusual, and we don't think it's possible for the government through speech alone to transform private speakers into state actors. We think these cases usually are and ought to be viewed through the Bantam Books type framework, where there's a problem if the government is engaged in coercion, but if it stays on the persuasion side of the line and all we're talking about is government speech, then there's no state action and there's also no First Amendment problem.
One final question. You continue to refer to government speech. Just for my edification, what's the constitutional basis for government speech?
Yeah, so the court has said, I think, that the government is entitled to speak for itself. It's not a right that comes from the First Amendment. It's a feature of our constitutional democracy. As the court has said, the government couldn't function if it couldn't express points of view. In Walker, the court explained, for example, that the government has to be able to run a vaccination campaign at times of public health crisis. I think that's a major part of what was going on here. So the court hasn't located it in any specific constitutional provision. It's just part of democratic governance.
Explain to me what exactly is the injunction doing? Meaning, how is it affecting your speech, the government speech? I know there's a lot of defendants.
Yep.
There's a lot of agencies. I know that our case law says an injunction just can't tell you to violate the law, and so this injunction might have that problem inherent in it. But the Fifth Circuit injunction is what's before us, correct?
Correct.
And it says to encourage or significantly to coerce, that's a legal term.
Yep.
Or significantly encourage, and you're questioning what the meaning of significant encouragement is. And I'm not sure I know exactly what the Fifth Circuit meant, but we can figure that out. Let's just use to coerce social media companies to remove, delete, suppress, or reduce, including through altering their algorithms, posted social media content containing protected speech. How is that harming the government? I want some specifics.
I'm happy to do that, and I'll say first, just to be clear, because this court has stayed the injunction, fortunately it's not harming the government now, but there were times when we were getting— Exactly, right. So I think the problem with that, we don't say that the government can coerce private speakers. That is prohibited by the First Amendment. But the problem with the Fifth Circuit's injunction saying don't coerce or significantly encourage is that it comes at the end of 80 pages of legal analysis, holding that the government had done those things by, for example, when the FBI would send communications to the platforms saying, for your information, it is come to our attention that the following URLs or email addresses or other selectors are being used by malign foreign actors like Russian intelligence operatives to spread disinformation on your platforms. Do with it what you will. That, the Fifth Circuit held, is coercive because the FBI is a powerful law enforcement agency. And I think if the injunction were put in place, the FBI would have to think very hard about whether it could continue to do that. Similarly, I think both the Fifth Circuit and my friends have really said that the crux of what they claim was coercion here was what happened in July of 2021 when the Surgeon General, the White House press secretary, and the President himself made statements criticizing the platform's practices on misinformation and false statements about COVID vaccines and calling on them to do better. I think it's really troubling, the idea that those sorts of classic bully pulpit exhortations, public statements urging actors to behave in different ways might be deemed to violate the First Amendment. And I think if the injunction were to go into effect and the President or his senior advisors, the President isn't enjoined, but if his senior advisors, the press secretary or someone else, wanted to talk to the public about other problems like the circulation of anti-Semitic or Islamophobic content on the social media platforms, or the effects they might be having on children's mental health, or national security issues like the anti-Semitic anti-Semitic Osama bin Laden letter that was trending on TikTok at the end of last year that we referenced towards the end of our brief. I think all of those things could be done only under the shadow of the injunction, and that comes around to the other point that you made, which is that this injunction, especially read in light of the opinion that comes before it, is extremely vague. And I think having that sort of vague injunction with these contestable legal terms that have been interpreted very broadly as applied to past conduct, hanging over the heads of all of these government officials doing all of these things is a real problem. And I think especially so when you're talking about entering such an injunction at the behest of 2 states and 5 individual social media users whose main complaints are about the moderation of posts about COVID-19 many years ago that they haven't really even shown were traceable to the government to begin with, we think. And we certainly don't think that they've shown that they face the sort of imminent threat of future injury that's required to satisfy Article 3.
Mr. Fletcher, let me follow up on that. If even one of the plaintiffs has standing, then we're required to get to the merits. So let me ask you about Ms. Hines. And as you just mentioned, she must have faced an imminent threat of future injury at the time when the complaint was filed, and that injury must be traceable to the actions of the government. So in the first part of that, imminent threat of future injury, her Facebook personal account was restricted at the time when the complaint was filed. So why isn't that sufficient to show a threat of an imminent threat of future injury?
We're not disputing that when the private platforms moderated the plaintiff's pages or their posts, that's an injury in some sense. We haven't disputed that. They suffered that injury. We've disputed the traceability question and then the redressability question.
Right. So on traceability, traceability is basically a question of causation, right?
Agreed.
All right. Both the district court found that the injury was traceable to the government's actions. And the Fifth Circuit accepted that finding, reviewed it, and accepted it. So that's 2 lower courts. We don't usually reverse findings of fact that have been endorsed by 2 lower courts. And you haven't attempted to show that it was clear that that finding is clearly erroneous.
So respectfully, Justice Alito, I disagree with that. I think that the Fifth Circuit and the district court applied too loose a notion of traceability. They didn't try to say this post or any action against Ms. Hines was traceable to any action by the government. They did what the red brief calls a bird's eye view of traceability. They said the government is talking to the platforms a lot. The platforms are doing moderation. And so we'll just assume that all of that moderation is traceable to the government.
Well, do you think that it's necessary to identify a single government action and then trace it to a single consequence? Do you think that's required?
No, but I think you have to trace some government action to some consequence that befell you. And maybe I could just be specific about this because we challenged this in our opening brief, and the red brief comes back at pages 19 to 21 and offers up what I take to be their best examples of traceable harm. And I invite you to go look at the pages of the record that they're citing, because often what you find is that they're citing moderation of their content that happened either before the challenged government actions to which they're referring or long after.
All right, I have looked at that. On the issue of causation, under Malhealthy, are they required to show anything more than the government's action was a motivating factor?
I don't know the answer to that in all cases, and I'm reluctant to make sort of broad statements about what the traceability requirement demands in different circumstances. I will say here, we're not disputing that. We're saying that they haven't shown any causal connection between the—
Has no effect whatsoever.
Right. And the reason—
Both the lower courts were wrong on that.
I think they were, because again, they did this blunderbuss approach where they said the government is talking to the platforms about moderation and the platforms are moderating content, but the platforms were moderating this content long before the government was talking to them. They had powerful business incentives to do the same thing. The acts of moderation were consistent with the platform's own policies. And this is, I think, another telling fact. In those red brief examples that we talked about on pages 19 to 21, some of them involved platforms like LinkedIn that wasn't even the subject of the challenged White House and Solicitor General, or Surgeon General's office communications with the platforms.
Do you think that there are any factual findings with respect to standing that we are required to give clear error review to?
I think findings of historical fact, absolutely. We're not fighting that. So the idea that pieces of content were moderated, that the government made certain statements, and if there had been findings that said Facebook deleted this post because of these communications by the government, that would be a factual finding of historical fact, but there just aren't such findings.
Right. I mean, that's what I was really getting at. Are there findings that you concede, That one, you have to apply clear error review to. That one, you have to do the same.
Yeah, we do, and I can't give you a list because there's a lot of facts in this case, but we agree historical factual findings count. What we say don't count are findings that are really characterizations, which is a lot of what my friends are relying on, findings that are about the application of law to facts, which in this constitutional realm we think get de novo review, and then findings that are premised on erroneous legal standards.
So, Mr. Fletcher, I just want to nail down what your views are on the legal standards. Sure. On traceability, you're not disputing that a motivating factor is enough.
We haven't made that argument here, that's right.
Okay. And then on redressability, what's your view of the legal standard the court should be applying?
I think, again, it has to be some showing that I think likely to redress the injury is the standard from Lujan. So it doesn't have to be certain, but you have to make some showing that an injunction against the government will stop the platforms from doing what they want.
In Massachusetts versus EPA, we've said likely to some extent. Does that strike you as correct?
I think in the context of Mass versus EPA, maybe where you're talking about a problem of degrees, here where the concern is, are the platforms going to moderate my posts or not, and are they going to do it because of the government or not, and will an injunction against the government stop Facebook and...
To some degree, is that an acceptable standard to the government?
I guess
I just want to know what my yardstick that I'm supposed to measure these allegations against, and there's not a lot in your brief about it. So I take likely from Lujan.
Yeah.
I take to some extent from Massachusetts versus EPA, and I take the statement in Larson that it doesn't have to redress every injury.
Agreed.
You agreed with all of that?
Except that to some extent, I think, was there the state's injury was about rising sea levels, and so to some extent means it doesn't have to solve the problem, it has to help it a little bit. This is more discrete acts of content moderation.
Do you agree with that standard, though, that to some extent, if they could show that their injury would be remedied to some extent by an injunction, that would be enough?
Correct. So if they're likely to face moderation on 10 posts and an injunction against the government would make it 8, that's enough.
Okay. And then just flipping back to traceability, I'm sorry, I forgot to ask. The substantial motivating factor obviously means it doesn't have to be proximate cause.
Agreed.
Okay. Thank you.
Mr. Fletcher, when I read all of the emails exchanged between the White House and other federal officials and Facebook in particular, but also some of the other platforms, and I see that the White House and federal officials are repeatedly saying that Facebook and the federal government should be partners. We're on the same team. Officials are demanding answers. I want an answer. I want it right away. When they're unhappy, they curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms, and they want to have regular meetings. And they suggest, they suggest rules that should be applied, and why don't you tell us everything that you're going to do so we can help you and we can look it over. And I thought, wow, I cannot imagine federal officials taking that approach to the print media, our representatives over there. If you did that to them, what do you think the reaction would be? And so I thought, the only reason why this is taking place is because the federal government has got Section 230 and antitrust in its pocket, and it's, to mix my metaphors, and it's got these big clubs available to it. And so it's treating Facebook and these other platforms like they're subordinates. Would you do that to the New York Times or the Wall Street Journal or the Associated Press or any other big newspaper or wire service?
So there's a lot packed in there. I want to give you one very specific answer first and then step back out to the broader context. So specifically, you mentioned demanding an answer right away and cursing them out. The only time that happens is in an email that's about the president's own Instagram account. It's not about moderating other people's content.
Okay, we'll put that aside. There's all the rest. Constant meetings, constant emails. We want answers. Right. We're partners. We're on the same team. Do you think that the print media regards themselves as being on the same team as the federal government, partners with the federal government?
So potentially in the context of an effort to get Americans vaccinated during a once-in-a-lifetime pandemic. And I really think that piece of context, it doesn't change the First Amendment principles, but it's relevant to how they apply here. And I think it's important to understand that at this time, this was a time when thousands of Americans were still dying every week, and there was a hope that getting everyone vaccinated could stop the pandemic. And there was a concern that Americans were getting their news about the vaccine from these platforms, and the platforms were promoting, not just posting, but promoting bad information.
I understand all that, and I know the objectives were good. But once again, they were also getting their news from the print media and the broadcast media and cable media, and I just can't imagine the federal government doing that to them. But maybe I'm naive. Maybe that goes on behind the scenes. I don't. But it struck me as, wow, this is not what I understand the relationship to be. That's all.
But I do. I think this is important because I have the same reaction that you do, that these emails look unusual. I think the idea that there'd be back and forth between the government and the media isn't unusual at all. When the White House press secretary on July 16th is asked about this by the press at the time, what she says is, of course we talk to the platforms just the way we talk to all of you when we have concerns about what you're doing, when we have information that you might find helpful. Now, there's an intensity of the back and forth here, and there's an anger that I think is unusual, but the context for that, I think, is that these platforms were saying publicly, we want to help. We think we have a responsibility to give people accurate information and not bad information. And we're doing everything we can to meet that goal. That's where this language of partnership comes from. It's not just from the White House. It's these platforms, which are powerful, sophisticated entities, saying we're doing the best we can. And the anger, I think really most of the anger when you read the emails, and I appreciate that you have because I think you have to look at them in context, the anger is when the officials think that the platforms are not being transparent about the scope of the problem or aren't giving information that's available.
Well, let me ask you one more question, and then I'll stop, at least for now. You make a big point in both your brief and your reply that states don't have First Amendment rights. But are you saying that they may have a free speech right, but it comes from someplace else, or they don't have free speech rights? Do you think that the federal government could prohibit a governor or the top-ranking public health official in a state from speaking to the residents?
No, I don't think it could, and I want to be clear. We're not denying that they have speech rights. We're saying that those things, like the federal government's speech rights, come from the structure of our Constitution, not from the First Amendment. This is a First Amendment case, and I think really what's happening here is that these states, which were the motivating factor behind the suit, the only plaintiffs in the initial complaint, are really trying to represent and to litigate the First Amendment rights of their citizens on their citizens' behalf. We think that's an end run around the limit on parents patriae standing, just like the one the court rejected.
Do you think, on the anger point, I guess I had experienced government press people throughout the federal government who regularly call up the media and berate them. Is that not your understanding? Or you said the anger here was unusual. I guess I wasn't entirely clear on that from my own experience.
That's fair. I guess I don't want to endorse berate, but I guess I will say I bet this is not the first time that there's been profanity or intemperate language in exchanges between White House or agency communication staff and members of the press.
Well, I don't know whether our public information officer is here today, but maybe she should take a note about this. So whenever they write something that we don't like, she can call them up and curse them out and say, why don't we be partners? We're on the same team. Why don't you show us what you're going to write beforehand? We'll edit it for you, make sure it's accurate.
So, Justice Alito, this is why I want to be careful here. I'm acknowledging the reality that this happens and that it may be commonplace. I'm not saying it's a good thing or a great thing or a thing to be celebrated, but fundamentally I'm saying the First Amendment isn't